The state's criminal act of obstruction of justice via theft of property by entity and unlawful denial of legal relief. This is in reference to civil case Erica Lorraine Spencer v. Bill and Wags Incorporated, case number CIVDS 1930644. Theft of property by entity and the unlawful denial of legal relief by state facilitating venue, the San Bernardino Superior Court, is a cooperative criminal act of obstruction of justice by the entity that is engaged in federal group stalking and monitoring, which includes the Ontario Police Department. Officer J. MEZA, number 20302 of the Ontario Police Department. Barry Plotkin, California bar number 41518. Judge LYNN M. PONCIN, California bar number 180349. And this is the judge originally assigned to handle my case that I filed against Bill and Wags on October 11, 2019. However, it is notable that Judge Kimberly S.Y. APALOO, California bar number 192860, finds her way to participation in this criminal act of obstruction of justice, which is the theft of my personal property, and then the unlawful denial of legal relief by the state facilitating venue of the San Bernardino Superior Court. This same Judge Kimberly S.Y. APALOO, California bar number 192860, is the same judge that engaged in kidnapping me via a fictitious prosecution at the Rancho Cucamonga Superior Court, in concert with the Ontario Police Department and the San Bernardino County Sheriff's Department. This is not a coincidence, and this is the same judge participating in both instances, and this is most notable, and this is why I'm pointing it out. She is engaged in both criminal acts and acting in an official capacity as a judge. This is a state actor. Kimberly S.Y. APALOO engaging in kidnapping and also engaging in what is theft of my property by virtue of participation in this civil case, which was nothing other than tantamount to the unlawful denial to confirm the theft of my property by the entity that is monitoring. Okay. So Danielle Little, California bar number 239784. The San Bernardino Superior Court, the California Department of Motor Vehicles, and the people of the state of California, including Bill and Wags Incorporated. Theft of property by entity is the state's method of inflicting terrorism, harassment, and oppression. Meanwhile, federal group stalking and monitoring in concert with the people of the state of California remains ceaselessly underway, while a pattern of kidnapping by the entity and unlawful denial of legal relief by the court coexists. Theft of property by entity is a criminal act of obstruction of justice posing an impermissible threat, and it is accomplished via the state's exercise of fictitious authority, and fictitious it is indeed. The entity that is criminally monitoring is exercising fictitious authority under the laws that it uses to substantiate actions that it is taking. While it is engaging in criminal conduct, it is the exercise of fictitious authority. And this entity engages in the exercise of fictitious authority under the laws, including California Vehicle Code Section 22651, subsection K, Ontario Municipal Code Section 4-6.309, subsection A, and California Vehicle Code Sections 22651.07, subsection C, subsection 2, and 22651.07, subsection C, subsection 3, subsection A. The state facilitating venue that is the San Bernardino Superior Court then engages in a pattern of unlawfully denying legal relief to which I am manifestly entitled under the applicable rules and laws governing the court, my case, and according to that which is appropriate and necessary as a matter of justice. This is the state's pattern of conduct.
All right, Erica Lorraine Spencer, this is the P.O.C. This particular piece of documentation is real-time documentation that was gathered at the San Bernardino County Superior Court, located off of 3rd and Arrowhead in San Bernardino, California. This is captured on October 16, 2019, where I did go to this court in order for an ex parte hearing. It's an emergency hearing. The fact that my vehicle was stolen by Ontario police who were engaged in federal group stalking and monitoring, specifically with regard to a criminal act of obstruction. And this is where the targeting entity is engaging in criminal acts they are criminal because they serve the purpose of harassing, threatening, intimidating, ultimately seeking to oppress the targeted individual that is documenting the state, that is monitoring that target individual. The state knows that you're documenting them because it's monitoring you, and so the state becomes increasingly aggressive upon the targeted individual's awareness. So upon my engaging in documenting the police, upon my engagement and documenting the fact that airplanes and helicopters are present and following me everywhere that I go, and documenting license plates of police officers in more than one county, not just Ontario, Los Angeles County, San Bernardino County, Orange County. This is the rising aggression of the state. Theft of your personal property is a criminal act of obstruction of justice. This is the pattern of conduct with regard to federal group stalking and monitoring, and the court is a facilitating venue engaged in criminal obstruction of justice, serving to conceal and insulate that targeting entity, that is the state, from exposure and prosecution ultimately by the targeted individual. This is documentation of not only am I being monitored, I'm subject to monitoring. The state does not at any time ever stop monitoring with communication devices. This is also documentation of what is criminal obstruction of justice in a facilitating venue. That is the San Bernardino Superior Court, and this is documentation of that. Understand, every word that is spoken in the court hearing, in the hallway, everything is audible activity, while I am constantly surrounded inside and all around the courtroom. I also have real-time documentation, and I will state those time capsules where you can forward to those moments in my documentation because you might not want to listen to the whole 3 hours. But understand that there is no law that is going to preclude the targeted individual from documenting a government engaging in criminal monitoring that is inherently threatening to the very life, the physical safety, and overall well-being of the targeted individual. And this is that which is also not private. The state is monitoring me to every word that is uttered, even inside of the court. There is no privacy law that is protecting it whatsoever. And in addition to that, this is also documentation of a judicial officer engaged in criminal obstruction of justice, monitoring me inside of the courtroom, engaging in harassment, making light of that which has a very vital effect and catastrophic effect. The state engaged in monitoring, systematic harassment prior to my awareness of being monitored on my job, so that is my professional life with regard to a place of worship where I used to attend church, systematic harassment, which I've also documented, and upon becoming aware of it, moving out of my own personal home, aware that my privacy was being invaded, becoming aware of documented stalking conduct by absolute strangers, all of them with communication devices in their hands. I mean, whether they're in vehicle, whether they're on foot, this is a pattern that I began to document. This was coincided with the ongoing ubiquitous presence of the police, and this is in every county. I literally drove through county to county documenting and observing what it was occurring. And the aircraft, stalking by planes was not immediate. It was police first. The state began stalking by aircraft literally down to the day, December 18th, 2018, when I began documenting. And this is while I was parked nowhere near any airport. I was parked living in my vehicle in Pomona, California, parked on Valley Boulevard at Valley and Temple, and the state was literally flying in a line that is patrolling, repeatedly crossing path, plane after plane over my vehicle all day and all night. This is when I began documenting the state stalking via aircraft in combination with the state via police and with third-party group stalkers engaging in a behavioral pattern, which I have soon become aware of, serving the purpose of monitoring with communication devices. And this is how you get to the elements of monitoring. This is federal group stalking and monitoring inside of a courtroom. This is an act of criminal obstruction by Barry PLOTKIN, engaging in monitoring and also engaging in harassment, making light of that which is a very serious and threatening situation with regard to the theft of my vehicle by police engaged in monitoring and engaged in theft of property. That's a criminal act of obstruction of justice. And this is that which I have designed to address under what I advocate, which is SIIS legislation, systematic infliction of inhumane suffering. The state has been documented engaging in a plethora of criminal activity which is intended to silence and oppress the targeted individual. And ordinarily one who has no idea about their rights, who lacks the wherewithal to even perhaps comprehend what is occurring, and is ultimately sought to be dismissed from society and regarded as suffering from a mental illness. That's the pattern of conduct. That's the P.O.C. And so with regard to this, I want to go ahead and identify the times at 2 hours and 46 minutes and 20 seconds. This is where you can fast forward to that, and this is where the hearing, my hearing begins. Erica Lorraine Spencer v. Bill and Wags Towing, and this is ongoing monitoring. So understand that monitoring is from beginning to end, at 3 hours and it starts at 2:46:20, 2 hours 46 minutes and 20 seconds. It goes into recess, and as I sit in the hallway, you might want to listen to that because P.O.C. is captured. I am addressing a third party that is engaging in patrolling conduct, that is pacing back and forth on foot, and I actually address it, and I ask him, "Oh, you're getting your aerobics?" What I am doing is I am addressing the fact that he is pacing back and forth in front of me. And actually, after I address it, more third parties in that hallway engage in doing the exact same conduct. Understand that this is monitoring conduct. It is also demonic, okay? This is that which the state does by the group of third parties in their vehicles. When I'm talking about looking at the forest from the trees, you're not looking at one car driving past and another car driving in the opposite direction. You are looking at the state operating vicariously through a unified group of third parties who are literally engaging in all manner of direction around you. This is the state pacing around you back and forth and back and forth. The state is pacing via aircraft and helicopter, flying in circles around me. That is demonic relevant positioning. It's monitoring conduct, and it is also demonic. The state does the same conduct by helicopter and by airplane. The state is engaged in acting vicariously. As I am sitting in the hallway, third parties are monitoring, and at 3 hours and 18 minutes and 37 seconds, you will also hear me address the fact of an airplane flying directly crossing path as I'm sitting in the court and I am looking at it fly past. This is P.O.C. as I'm addressing it verbally. The hearing resumes at 3 hours and 22 minutes and 30 seconds. You can hear the rest of the hearing. This is documentation of what is criminal obstruction of justice by the state. The state is represented by the court, okay? The state is represented by the jail. The state is represented by the police, engaged in a system of not only federal group stalking and monitoring, but that which is criminal obstruction of justice, which is within the pattern of conduct, where the state is seeking to insulate and conceal the fact that it is operating this criminal monitoring system, and it is designed to silence and oppress the targeted individual that is documenting, reporting, or otherwise exposing, seeking to prosecute that targeting entity. And that's the significance of what I've documented. It is P.O.C., and you can go ahead and listen to that now.
Done deal from here, huh?
you need help with learning how to read that?
I don't
Do you have a case in there?
No speak English. No
So
English.
you don't read English either?
No.
So you're staring at English. Do you need help reading it? Is that why you're staring at it so long?
Me no English.
Of course.
Yeah.
It's all in English.
Yeah.
Yeah. Todos en inglés. No español.
Nada español.
You're sitting there staring at English. You can't read, right? Got it. God. Oh, you understand English. Bye, hombre. No, stalking is rude, honey. Take yourself on down. You're a criminal. And an anorexic criminal. You're an anorexic criminal. Go eat something. Being rude. Bitch, you over here breaking the law. Get the fuck out of here. That is here in the San Bernardino courthouse. It's no wonder why the government continues to engage in conduct when it knows full well that I am initiating civil litigation against it, because it has no reason to fear. The criminals are right here in the courthouse. They're right here. That's why. Standing over, huddling around me, because they're using technology. That's all they need to do. In front of S15 that clearly says it is dark. There are no cases in here. But hombre who claims he can't read English is just staring at the sign that's in all English, huddling around me. It's the same pattern of conduct here at the Justice Center. This man sits down here with his phone and camera on me, conforming to the pattern of conduct. Over here by the apartment that I'm getting ready to move into, it's the same thing. It's exactly why the government is continuing what it's doing. This is all a stage. All of it. Make sure you don't use your phone in there.
Huh?
Make sure you don't use your phone in there in Mr. Michael's desk courtroom.
Oh, yeah, I see what you mean.
Oh, yeah.
Okay, all right. Oh, yeah, they get mad if you use the phone in there. Yeah, there's nobody here. I was wondering if I'm in the right area.
Oh, you're here doing exactly what you're supposed to be doing.
This is the courtroom. The last time I checked, the courthouse.
Right. I'm going up to 31 to check in. Okay. Up there.
You coming back?
Well, you got one up there. I'll probably request priority. Nothing near as crazy as yesterday.
Am I able to request priority?
Still moving here.
Okay. All right. He's gonna go pick his one and then he'll be back.
Excuse me, I'm
Yes, ma'am.
sorry. Was that hand raised toward me?
No, yeah, I was just saying, just 1 second.
Oh, okay.
What can I do for you?
I just want to find out if I can request priority.
I can let the deputy know.
Oh, okay.
Okay.
Well, I have like a cardiologist appointment in the afternoon, so I have like a big, huge window. I wasn't getting anything done. That's why I had to turn down that settlement conference because I have an appointment.
Good morning, Court Call.
Are these sinuses or?
Good morning, this is Joy, the court call operator, and I'm calling to connect Judge Barry Platkin's 8:20 a.m. Pacific Time calendar. Would you like to know which attorneys are online?
Sure.
And to a moment, please.
Oh, I went ahead
How are
and
you?
Okay, thank you. What's your name?
Matter upstairs.
Cindy? Okay.
Yeah, I think he's probably like 18.
Yeah, no, she's 17.
Still have.
I mean, I'm sorry, she's
Excuse me,
16.
Madam Clerk.
Yeah, no, she's 16.
Yes, we have
We're
checked
doing 2
in
departments in here
for
today, so.
Michael Brewer, and he is requesting for priority. We also have Sam Allen,
Thank you.
Janine Jeffrey.
17.
Okay.
We also have Jason Meyer, and he is substituting for Karel Rocha. Would you like to have the spelling of his name?
Yes, please.
First name is Jason, that's Jason, and last name is spelled as Meyer. We also have Karina Villa, substituting for Mark Israel. Would you like to have the spelling of her name?
Sure.
First name is spelled as KarinA. I'm sorry, it's Mark R. Israel. And last name is Villa, Villa.
And the next check-in, please.
That's all as of the moment, Madam Clerk.
All right, and you also should have 2 check-ins for Department 16 for Judge PONCIN. They'll be coming through it with you as well.
Okay, that will be noted. Thank you.
Number 24. You think? No, I don't have any.
And excuse me, Madam Clerk. the names of the two check-ins for Judge Ponson?
Go ahead.
May I have the names of those two that will check in for Judge Ponson?
James Felton and Ashley Kay.
James, and may I have the spelling of the last name, please?
I don't understand your request.
I'm sorry. What is the last name of James?
Felton, Felton.
Okay, and the other one is?
Ashley Kay, Kaye.
All right, thank you.
Are there any other check-ins for Department 17?
None at this time, Madam.
Thank you.
Just a friendly reminder, if you have a cell phone, please silence or turn it off.
Court call operator, do we have any more check-ins for 17? Court call operator.
Please remain seated and come to order. Court is now in session. The Honorable Barry L. Plotkin presiding.
All right, so how are we going to do this? Okay. I mean, start with S16, 17? All right, we have two calendars today. This is Department S17, and we also, Judge Poncin is not here. She presides in Department S16, and will be doing her calendar as well. But we're going to take Department S17's calendar first, and then S16. If your name is called and you're not represented by an attorney, please come forward to the council table. Oh, we may go back and forth between S16 and S17, depending on if we have attorneys who are requesting priority. All right, Mr. Morris, Les or LES Financial versus Valdez, bankruptcy files.
I don't have that case.
Oh.
I mean, I'll appear if you want me to.
No, I don't. Cervantes and Garcia versus Family Auto Sales.
Good morning, Your Honor. Robert Morris on behalf of Plaintiffs' Counsel. Your Honor, this case is fully settled. They are waiting for the payment of settlement funds and request 45 days to receive those and dismiss the case.
All right, the minute order should so reflect. And let me get organized here. All right. So we'll show the case is unconditionally settled. The plaintiff is ordered to serve a notice of settlement, and I'll continue the matter 60 days to December the 16th, 2019. In this department at 8:30, or in order to show cause or a status of settlement / dismissal.
We'll do that, Your Honor. And we'll give notice.
Okay, is that all you have?
That's it. Thank you, Your Honor.
Your Honor, we got December 19th.
December 16th. All right. Here's number 2, and then we're going to call number 4 on Department 16's calendar. Well, this is 17. I'm sorry. All right. Cisneros versus Matthew, something City of Redlands.
Good morning, Your Honor.
No, I've got the wrong case. I'll take your case, Mr. Deason-House,
Thank you, Your Honor.
since you're here. I've had a chance to review this. The murder was granted on June 20, 2019, 45 days given leave to file an amend. Defendant's incarcerated in a mental facility. Court allows additional time for receipt of amended complaint. Is Mr. Cisneros on the phone? No.
We filed a motion to dismiss for failure to amend, Your Honor. It's set at the end of this month.
Okay. We have a date.
I believe it's October 27th.
October 23rd. Okay, it's on here. All right. We'll show that plaintiff has failed to amend the complaint. The defendant has filed a motion to dismiss the action for failure to amend within the time allotted by the court, and will continue the matter to the date currently set for the hearing on the motion, which is October 23rd, 2019. Plaintiff to give notice, and plaintiff to give notice of our, we'll give Mr. Cisneros our phone number. Okay. Defendant to give notice, of course.
Pass me your line?
Let's give you our phone number, so you can give it to him so he can call in if he's able to.
The number right here is 909-708-8715.
We'll do it again.
You don't have one.
909-708-8715.
And tell him he may call in at 8:30.
All right, I will put that in the notice.
All right, thank you, Mr. Diaz. Hi, Mr. Brewer. Electronics versus Jordanos, Marai. I've not looked at this matter yet this morning. What's the status of the receivership?
Good morning, Michael Brewer, court-appointed receiver, appearing by court call. We have been trying to get in touch with the defendant licensee. We've had no success, so we're moving forward with selling the license. It appears that they also have a tax lien that will be dealt with as part of the license sale as well. This type of license is not a huge demand for, so it's going to take me a little bit of time to find an appropriate buyer.
We show the receiver has been unable to contact the individual defendants, and the license is going up for sale. Mr. Brewer anticipates it may take some time to consummate a sale. I'll continue the matter to March 16th, 2020. That's about 5 months. For an order to show cause, raise status of the receivership. I'd ask you to file a declaration 10 days prior to the hearing. You may have done so, but I didn't see it. But do file a declaration.
I did file a declaration, yes.
Thank you very much. It's my oversight that I didn't see it. File a declaration 10 days prior to the hearing, and if you have a contact address, you can give notice. Otherwise, no notice required. All right, that's the court's order. All right, you've got this all organized. All right, number 19. Raul Gutierrez versus Joel Espejel.
Good morning, Your Honor. Raymond Perez for the plaintiff.
Mr. Perez, we continue this from September 12th. You didn't make an appearance. The court said in order to show cause why you shouldn't pay $100 in monetary sanctions for failure to appear, and $50 in monetary sanctions for failing to serve the summons and complaint within 160 days, within 60 days of the filing of the complaint. You were ordered to file a declaration. You've not filed a declaration.
I did file a declaration.
You just filed it Thursday. And you know it hasn't reached the file yet, but tell me what it says.
Okay. This action was based on personal injury as a result of an automobile accident. We had a secretary who was assigned to do a DMV search for us. That secretary is no longer with us. She put the file, she remained with us till April 2019. She put the file in an area that we could not locate that file. We spent the last 4 months searching for this file, and we finally located it. So that was apparently the fault of my office. However, like I said, the secretary is no longer with us.
Well, but you need professionals to locate defendants and to do searches of whereabouts. Secretaries aren't the best people to do it. Why didn't you appear?
We did not have notice of the September, I did not have.
Yes, you did. When you filed the complaint, you were given notice. It's right on your...
Okay, it was not on my calendar, Your Honor. The defendant is insured through Allstate. We've been trying to...
See, that's what I figured. You're trying to settle the case rather than serve it. And that stopped 20 years ago, really. The Judicial Council ordered that you can try to settle the case if you have the insurer's contact information, but you must serve the complaint within 60 days so that we can get the process started, because you're just delaying the ultimate process, because if you don't settle it, it goes to trial. This action was filed back in March. Just a moment. This action was filed back in March. It's now October, 6 months later, and you still haven't served it. I'm going to impose a $100 monetary sanction for failing to appear on September 12th, a $50 monetary sanction for failing to serve the summons and complaint within 60 days. That sanction is payable by October the 31st to the clerk of the court. And I'll order you to forthwith serve the defendant, and I'll continue the matter 60 days to December 16th, 2019. If you do serve the defendant, it will also be set for a trial setting conference, and you'll give notice of the next appearance.
Yes, sir. Again, we apologize. We did lose the file, and we did locate it after.
All right.
And it is out for service.
Very well.
Thank you.
That's the correct order. Okay. All right, at 26, we have counsel who is present. The counsel also on court call. Let me turn to that file for a moment. Brown versus Ontario Police Department. Notice of demur and demur to the complaint, a plaintiff's appearance.
Yes, Your Honor. Scott Humphrey appearing on behalf of the plaintiff on court call.
Good morning, Your Honor.
This is my first day back after a 2-week hiatus, but they've been sending me the motions, but they didn't send me this one. So this is I have a demur, an opposition to a demur, and a reply. And all I can do is and is there a research memo? There is a research memo. Oh, I did read this. You know what I did? I read the, they did send me the briefs, and I did read them, but it was about a week ago. So I need to reread the briefs. And why don't you have a seat at the council table? And I'm going to take 5 minutes and reread the briefs while you're here, so I don't have to continue the case. Otherwise, I'm going to have to continue it. But you're both here, and you both fully briefed the matter. And so have a seat, and then counsel on court call. I'll be with you in just a moment after I read. You can have a seat at the council table.
Okay, Your Honor, if I can just ask one bit of leniency here. Yeah. I'm downtown right now in Los Angeles, and I have an 8:30 appearance on the matter, which I've tried to put on jump back on court call.
Well, let me
I don't want to put out
let me
counsel for
let me
defendant.
put it over for 30 minutes, so I can do the calendar. How about, can you stick around for an hour? Oh, that's kind of you. What? 9:30. Yeah, all right. Let's make it 9:30, and I'll reread the briefs. The tentative ruling is to sustain the demurrer because I think the proper remedy is mandamus, but we'll get to that. I'll just give you a heads up. Okay, 9:30.
Thank you, Your Honor.
Okay, great. Thank you.
Mr. Farmer? On number 7, Department 17. All right, I have opposing counsel on number 20, and plaintiff's counsel, and defense counsel, and Everest National Insurance versus Rosas and Mulatto, with the cross defendant being Infinity Insurance, represented by the Daniels firm. I have 2 counsel in court. Let's get their appearances first.
John Farmer for Harlan Reese for Plaintiff Everest National Insurance Company.
Okay, Mr. Farmer.
Christian Aguiar for defendants cross Lieutenant Mulatto.
All right, and Infinity Insurance?
Yes, Your Honor. Karina Villa on behalf of Infinity.
Okay, you were the Daniels firm?
Yes, Your Honor.
All right, Mr. Farmer, what's this case about?
I believe Everest National filed an insurance subrogation case, Your Honor.
Okay.
And then, as I understand it, Mr. Anium cross-complained against the defendant's insurance carrier, Infinity Insurance Company, and then there's also a cross-defendant that's not served yet, which is the insurance agency. And so I think we have one party still out there. It's my understanding that written discovery between the parties already in the case is pretty much completed, and plaintiff was going to request a trial date in April 2020 or thereafter, but I think we probably need a continuance in that we still have trust defendant that's not in the case yet.
Are you going to pursue the case, Mr. Aniam versus Auto Coast Insurance Agency?
Yes, I will, Your Honor.
Why do you not serve them?
I apologize to the court for that. It's actually my fault in the office. I've had a number of personal issues that distracted me away from the office. My mother is very sick in the hospital right now, and I would forthwith attempt to serve on the coast.
Auto Coast?
Yeah, the Auto Coast.
Well, I'm going to impose a sanction for insufficient explanation for failure to serve. I mean, you have office staff. All you have to do is get the summons and complaint to your process server.
I do not have office staff.
You don't have office staff?
No, I do not.
You don't have a secretary?
No.
You don't have an investigator?
No, I do not.
You don't have anybody who serves process for you?
No, I have someone to serve that process for me.
Well, then that's all you had to do.
To the court. I overshadowed it due to personal issues.
All right, I'm going to impose a $50 monetary sanction for failing to serve the cross complaint on Auto Coast Insurance Agency. This is costing other attorneys time and money for their work and their appearances. And all you had to do is give it to your process server, and they shouldn't be hard to find and locate. That sanction is payable by October the 31st to the clerk of the court, but it's just going to necessitate a continuance of the trial setting conference, which I'll continue 60 days to December 16th, 2019. You're to forthwith serve Auto Coast, and upon receipt of a responsive pleading, give them notice of the trial setting conference. In the meantime, you should conduct whatever discovery you're able to conduct between the parties, except for depositions, which Auto Coast needs to be present for. This is worse than I thought it was. We continue the matter July the 10th for you to effect service of the cross complaint. July, August, September, October. So you've got 90 days to serve this. Correct?
That's correct, Your Honor.
No, this is inexcusable. I'll keep the sanctions at $50, but I'm going to reserve jurisdiction to impose a $150 monetary sanction. You're required to serve the summons and complaint within 60 days, and Judge Dess was kind enough to give you 90 days. So, are you sure you want to pursue Auto Coast Insurance?
Your Honor, I'd like to have that reservation.
What did they fail to do?
Well, Auto Coast is the agent.
What did they fail to do? What are you suing them for?
You know, they're the ones that wrote the policy for my client.
What's their liability?
The insurance is position is that my client was an excluded driver. We dispute that. So we wanted to have Auto Coast Insurance to provide some clarification to that.
So is Infinity's position that Rosas and Mulatto aren't covered?
That's correct, Your Honor. Infinity's position was that Rosas was an excluded driver.
Was an excluded driver.
Yes.
Well, let's get moving on this.
Very well.
Let's get moving on this, okay? You're costing other attorneys time and money. So reserve jurisdiction to impose a $150 monetary sanction, and you get Auto Coast and serve within the next 10 days. That's the court's order. No excuses. Okay?
I will do that.
All right, that's the court's order. Is notice otherwise waived?
Yes.
Your Honor, that's December 16th at 8:20.
Yes, it is.
Okay, thank you.
Okay, thank you very much.
Thank you, Your Honor. You're good from Infinity.
What?
Your Honor, did ask if notice are waived.
Okay. All right.
Thank you.
That's the court's order. All right, Mr. Farmer, Department 17, number 9. Portfolio versus Glenn Locke come to the table.
John Farmer for Hanson and his for plaintiff's portfolio. Your Honor, they've submitted a dismissal to the court, but it's apparently not been processed yet. If the court would please dismiss this matter without prejudice at this time.
On motion of plaintiff, so ordered.
Thank you, Your Honor.
Without prejudice. And then we're going to jump to number 17. Capital One Bank versus Chavez.
John Farmer for Nelson and Kennard for plaintiff Capital One Bank. As the court may recall, Ms. Hayashi informed the court back on August 15th that this matter had settled. I'm told that counsel mailed a notice of settlement to the court on Monday, I think it was Monday, October 11th. That was last Friday. So hopefully that is in the process of being received and filed
wondering why Judge Dest imposed this is number 17?
Correct.
He imposed a $100 monetary sanction for failing to comply with 3740 subdivision F and no default. Oh, it's over a year, that's why. Yeah. That sanction wasn't paid, so the court sent an OSC why an additional $100 shouldn't be paid. What's the status of the settlement?
The case is settled. Notice the settlement was mailed to the court last Friday.
All right, I'm going to impose the additional $100 in monetary sanctions for failing to effectuate and complete the settlement within 1 year of the date of filing, plus the additional $100 which was ordered on August 15th, that was due by September 17th. Total sanctions of $200 payable by October 31st to the clerk of this court, and I'll continue the matter, and this will be the final continuance, and I'll reserve jurisdiction to dismiss the matter if judgment isn't obtained or the settlement isn't effectuated, and I'll continue it to December 16th, 2019 for a final continuance.
12/16.
That's it, but they've got to pay those sanctions,
I'll remind
$200 by the
I'll
31st.
get the sanctions in to submit a conditional dismissal or a judgment package.
Right.
And plaintiff to give notice.
Right.
Thank you, Your Honor.
Number 18, LV in the funding versus Renee Saldana.
John Farmer for Harrison side for the plaintiff. Your Honor, they tell me that they are apparently, it looks like they're waiting for the affidavit to support the default judgment package. If the court is inclined to impose sanctions today, I would request the dismissal without prejudice.
The court is inclined to reserve jurisdiction to impose sanctions of $100 and continue the matter 60 days. You want me to do that?
That would be great, Your Honor.
All right, reserve jurisdiction to impose $100 monetary sanction. Continued 60 days to December 16th. Department 830. The sanctions aren't paid and the judgment isn't obtained. The court intends to dismiss the matter.
Could I clarify then, Your Honor, you're reserving jurisdiction, but you're not imposing the sanctions today, is that correct?
That's right.
Okay, thank you, Your Honor.
Number 21. Serengeti Financial versus Bauhard.
John Farmer for the Lannister
Corey Bauhard.
Lannister Law Corporation for the plaintiff. Your Honor, they've provided me with a stipulation for a settlement that has been signed by both the plaintiff and the defendant, and I'll provide it to the court attendant. It has a place for the court to sign it.
There's a fee involved.
It looks like
Stipulations require a $20 fee.
I'll tell them that they need to submit it then to the clerk's office with the $20
I'm going to sign
fee.
it, but order them to pay the $20 fee. But I'm going to strike while the iron's hot. And if they have a stipulation for settlement, I'm going to sign it. Pardon? And we'll hold it till we get the $20, and that's payable by October 31st. And judgment is entered in favor of plaintiff and against defendant pursuant to all terms and conditions cited above. The judgment will be held pending stipulation, and I'll continue it for an OSC ready confirmation of settlement or dismissal to November 19th, 2019.
Plaintiff to give notice.
21.
Thank you, Your Honor.
And number 24, Cavalry versus Rubalcaba.
John Farmer for
David
LYNN.
Rubalcaba coming to the table. This is a wage garnishment. Let's take a look and see what we have. All right, in this case, the opposition notes that the defendant improperly claims 3 dependents who are either adult children or granddaughters. The defendant, judgment creditor, will accept $87 per pay period.
I think that's per month, Your Honor. So as I read the opposition, they're just looking for 87 per month.
Plus the $12 for
I
the...
believe the defendant is paid weekly, so if the court would enter an order specifying $87 out of one paycheck per month.
87 plus 12 is 99. $99. I'll partially grant, partially deny the claim of exemption. The defendant's net earnings are exempt with the exception of $99, which may be levied upon the last pay period of each month, commencing forthwith. Clerk to give notice to the sheriff.
Thank you, Your Honor.
All right, now turning to Department 16 calendar, number 8. Portfolio versus Cazares.
John Farmer appearing for Hunton and Ricas for Plaintiff Portfolio Recovery Associates. Your Honor, they've submitted a dismissal to the court, but it's not been processed and needed yet. If the court would please dismiss without prejudice.
On motion of plaintiff, so ordered.
Thank you, Your Honor. Excuse me, Your Honor.
And Portfolio Recovery versus Kerr.
John Farmer for Hunton and Ricas for Plaintiff Portfolio. If the court would please dismiss this matter without prejudice. They also submitted a dismissal, but it's not been processed and entered yet.
On motion of plaintiff, so ordered.
Thank you, Your Honor.
Cavalry SPV versus Pozuelos.
John Farmer for Qual Perdo for Plaintiff Cavalry. Your Honor, it appears they filed a declaration on October 10th. They didn't give me a copy. As I understand the case, they have finalized the settlement agreement. It was sent to the defendant for the defendant's signature last week on October 9th. They're requesting 90 days continuance to get its settlement agreement signed by all parties and filed with the court.
I'm going to deny that because on July 15th, the same request was made that the case had settled, the defendant was making payments, but the defendant had not signed the stipulation for settlement. Judge PONCIN gave the parties 90 days to effect the settlement agreement and to have the defendant sign it. I'm going to deny the request for a continuance and set the matter for trial in January.
Actually, I don't think we have an answer, Your Honor.
Oh, we don't have an answer.
So if the court's inclined, maybe set an OSC rate default judgment for January, and I'll tell them they either have to have their judgment package submitted.
Well, I'll set it for an OSC rate dismissal / judgment December the 16th,
Thank you, Your Honor.
2019. And at that time, they'll either need a signed settlement agreement or a 585 default judgment. But Judge PONCIN gave them 3 months. They did not file a declaration.
Actually, they did, Your Honor, on October 9th.
We didn't get it. Okay, strike they didn't file a declaration. But for some reason, the defendant is willing to make payments but not willing to sign the settlement agreement, which is causing them problems. But they need to get the defendant's attention, and one way to do it is by getting a default judgment. Alright, this is Department 16 case, continued in that department. I'll also reserve, just a moment. Jurisdiction to dismiss the matter if no settlement or judgment is obtained.
I'll advise counsel accordingly and have them give notice. Thank you, Your Honor.
Number 17, Unifund versus HARASSMENT.
John Farmer, attorney for Kenosha and Miley for Plaintiff Unifund. In this case, Your Honor, they finally got service on August 25th, 2019. The proof of service is on file with the court. I would request that the court confirm the January 13, 2020 OSC rate status of default judgment hearing. Counsel tells me that they're going to move expeditiously to get the default and default judgment submitted now that the defendant's time to respond to the complaint has expired.
Granted, there's a current January 13, 2020 OSC rate default judgment presently set. Will show that the parties have settled.
No, Your Honor.
And they've not settled.
It's just a matter of doing their default and default judgment.
All right.
Now that the
for an OSC rate status of default and default judgment, plaintiff order to enter default of defendant forthwith and submit default judgment packet. I'll reserve jurisdiction to dismiss the matter if the court's order is not complied with.
So that's the OSC rate status default judgment on January 13th.
Yes.
Thank you, Your Honor.
And number 18, the Best Service Company Inc. versus John Lynch.
John Farmer, attorney for Christopher Stapleton for Best Service Company Inc.
Let me see their declaration that they filed. Declaration by Christopher Stapleton for a sanction for failing to file proof of service. Let's see. There's an amended summons and complaint was filed June 13. Went out for service. Still trying to serve the defendant. Plaintiff requests the hearing be continued 60 days. so the defendant can be served. The minute order should reflect that plaintiff filed a declaration, that plaintiff filed an amended complaint June 13th, 2019, and is still attempting to serve the defendant. I'll continue the matter to the 1-year review date of January 14th, 2020, and continue the hearing. This court set a hearing reserving jurisdiction to impose $50 in monetary sanctions for failing to comply with 3740E. I'll continue that hearing to July 14th. For the service, so I'm opposed to sanction.
You meant January 14th, correct?
What did I say?
July.
Oh my goodness.
So we're January 14th. Your Honor, will it be a trial setting conference if they obtain service and there's an answer?
Thank you for reminding me. If service is accomplished and a response to pleading is filed, it will be set for a trial setting conference at which plaintiff shall give notice.
Thank you, Your Honor.
19. Toyota Motor Credit versus Valenzuela.
John Farmer for Padilla and Felix for plaintiff Toyota Motor Credit. Your Honor, in this case, they did obtain service on July 26th. The defendant has not filed an answer. I would request that the court confirm the January 14th OSC rate status and default judgment hearing that is already on calendar.
Will do. I'll continue the matter to the which shows service was accomplished July 26, 2019. Plaintiff to obtain default judgment by the next hearing date, which is currently scheduled for January 14th, 2020. I'll continue the OSC that was set, reserving $50 in monetary sanctions for failing to strike that. That was for failing to strike that. Strike the reserve jurisdiction to impose the sanction.
I'll have plaintiff's counsel give notice.
Okay.
Thank you.
TD Bank versus McBride.
John Farmer appearing for plaintiff's counsel. Your Honor.
Reserved July 18, 2019.
I'm told that a default judgment package was sent to the court on September 30th. They are requesting that the court continue this matter pending the processing of the judgment package and the entry of judgment.
The defendant was served in a default judgment packet. Per plaintiff was sent to the court recently. When was it? When was it sent?
On September 30th.
On September 30th. I'll continue the matter 60 days to December the.
Your Honor, there's a January 15th date set. It's
There is.
You want to just confirm that, Your Honor?
Right. Confirm January 15, 2020 default judgment hearing date.
Thank you, Your Honor.
State Farm versus Marin.
John Farmer for Clifton Sinclair and Matthews for plaintiff.
Court call.
Yes, this is Catherine Lee for defendant Marin.
All right, this is a further trial setting conference. This is a limited jurisdiction. There's insurance subrogation claim. Nobody has posted jury fees, so we're going to set a bench trial.
Yes, Your Honor.
Yes, sure.
All right, when would plaintiff like trial?
About late April or in May, Your Honor.
Late April or May. Well, just a
maybe for
moment.
the better for defendant.
I'm gonna set it sooner. I'll tell you why. The action was filed January 14, 2019. The answer was filed February 28, 2019. This case should have come on calendar. The clerk should have set it for a TSC in April, and they failed to do so. So the parties, the case has been at issue for a substantial period of time. So let's set it in February or March. We've had plenty of time.
End of February would be
End of
better for
February.
defendant, Your Honor.
All right. Hopefully you should have completed discovery by now. But the end of February will do. 2-hour court trial, 4-hour court trial. No jury fees posted.
I would say 2 hours.
2 hours. Clerk will give us a date.
February 24th.
February the 24th and Department 16. What time does she set her trial?
9:30.
9:30.
Actually, set some at 10 o'clock in the office.
10 o'clock.
And I'll have counsel for plaintiff serve the S16 trial setting order.
Right, I'll issue the usual trial setting order to parties to exchange witness and exhibit lists and a short trial brief 10 days prior to trial. A plaintiff to give notice by serving copy of trial setting orders.
Thank you, Your Honor.
Thank you, Your Honor.
You're quite welcome. Thank you. You're excused. 22 PMGI Financial versus Hills.
John Farmer for
Jerry
petitioner,
Hill.
Miley for plaintiff PMGI.
No calls or check-ins.
The bank levy. It's a new law. I don't think it's effective until January 1st. It says you can't wipe out a bank account. You have to leave, I think it's $1,427 in the bank. There's a claim of exemption. Jerry Hill Sr., he's in Victorville. The property I claim to be exempt is Social Security retirement, Federal Civil Service retirement, military retirement. So one is Social Security retirement, which I believe is exempt. Federal Civil Service retirement, which I believe is exempt, and military retirement, which is probably exempt, but he's failed to appear to show proof of any of these.
On that basis, Your Honor, plaintiff would move to deny the defendant's claim of exemption.
Right, the defendant claims that all of the funds are exempt as various forms of government-funded retirement accounts. Without specifying the amount of each one. He's failed to appear to show proof of the source of the funds, or that they are exempt. Therefore, the claim of exemption is denied. Discover Bank versus Wayne.
John Farmer, Attorney Associates for plaintiff Discover Bank.
William Hopkins.
No calls or check-ins.
No appearance by defendant. Court trial motion continued July 15th to allow plaintiff to provide proper notice. the motion for summary judgment. I assume the plaintiff provided proper notice.
Yes, I believe so, Your Honor.
Aye.
It appears that notice of the new hearing date was given on approximately July 22nd.
Notice was sent to defendant on July 30.
Your Honor, this matter is set for court trial on December 5th.
Are you talking about number 23?
Yes.
It says motion for summary judgment. Discover Bank versus when?
Yes, Your Honor. At the time of the last hearing, when Judge Poncin granted my request to continue the matter, she also continued the court trial that had previously been set.
Okay, you're correct in one sense. So there was a court trial that was continued pending hearing of the motion for summary judgment. The court will hear the motion for summary judgment first. The court will grant the motion for summary judgment and grant judgment in favor of plaintiff, Discover Bank.
Did they provide the court with the proposed judgment, Your Honor?
They didn't.
I believe I had it at the time of the July hearing, but I apparently have actually, I have just found my order and judgment.
Do you have the amount of the judgment?
I have an order and judgment, but I need to correct the dates.
All right, let me sign it, then you can correct it.
Very good, Your Honor. Let me take a brief look at that date. It just needs to be changed from...
Let me sign it, then you can correct it.
Very good, Your Honor. I have two copies of the judgment. We'll just need to interlineate 715, and then I have a clean copy of the proposed order, and I have another that I can correct form.
I'll sign an order granting motion for summary judgment. We'll change the dates for the hearing. I'll grant the motion on a first cause of action of open book account, and the second count, account stated. The total judgment, for the judgment, so I'll sign the order granting the summary judgment motion. And I'll sign the judgment, which is in the following amounts: $5,893.20 in damages, $846 in costs. Plaintiff is waiving prejudgment interest and attorney's fees for a total award of $6,937.70. And I'm going to return this to Mr. Farmer. Here. You can change the dates.
I'll change the dates and run them back to the court then. Thank you, Your Honor.
Oh, I didn't do that. Okay, thanks. Hi. Yeah, I got to do that motion at 9:30. Is this Mr. Day? Okay, Mr. Day, number 10. Midland Funding versus Johnson.
Thank you and good morning, Your Honor. Cheryl Haday, appearing on behalf of counsel for plaintiff, who requests to dismiss without prejudice.
I can do that, and I will so order.
Thank you.
On motion of plaintiff. Number 13. TD Bank versus Echeverria, come to the table.
Thank you.
Why Echeverria?
Thank you, Your Honor. Cheryl Haday, appearing on behalf of counsel for plaintiff. This case is settled. They would like a continuance filed notice of settlement.
All right, we'll show the case is settled. Parties, plaintiff's order to file a notice of settlement. The defendant's answer has been stricken for failure to pay fees. I'll continue the matter 60 days for an OSC rate settlement / default judgment. The plaintiff is to submit either 664 dismissal or a judgment by December the 16th, 2019. Oh, wait a minute, this was just filed in April. I'll go to January 16th, 2020.
Plaintiff will give notice.
All right, let's go back to Department 17. LBNV versus Cabrera.
Thank you and good morning, Your Honor. Cheryl Haday, appearing on behalf of counsel for plaintiff. We request to dismiss with prejudice.
So ordered on motion of plaintiff. Number 14. Cavalry versus Janessa Rodriguez.
And thank you, Your Honor. Cheryl Haday, appearing on behalf of counsel for plaintiff. I'm informed that the $100 sanctions were paid this morning.
Okay, good.
And that the default judgment package was submitted, or was received by the court on September 18th. From the website, it does appear to be the case.
Well, that's very strange.
It took a detour somewhere.
Yeah, have the clerk follow up on it. It was routed to the department on September 30, but it obviously didn't make it. We show judgment packet has been submitted and is pending court signature. I'll continue the matter 30 days to Tuesday, November 19, 2019 for OSC rate status of default judgment.
Very good. Plaintiff will give notice. Thank you.
LBNB funding versus Shannon.
And thank you. Cheryl Haday, appearing on behalf of counsel for plaintiff. And on this one, the sanctions were also paid this morning. And the default judgment package was submitted on 10/15 by e-file.
All right, we show that the default judgment packet was e-filed October 15th. I'll continue the matter to December the 16th, this department 2019, for an OSC rate status of default judgment. And that's the court's order.
I will have plaintiff give notice. Thank you.
CACH versus, just a moment. CACH versus Jacob Jones.
And thank you. Cheryl Haday, appearing on behalf of counsel for plaintiff. And on this one, we're requesting to dismiss without prejudice.
So I'll vacate the sanctions.
Your Honor, also, I had a last-minute add-on 16's counter. I know if it got into your stack or not. It was number 14. Sorry, I didn't see it till the last minute.
Cook.
Yes, and thank you, Cheryl Today.
LBNB funding versus Angela Cook.
Thank you, Cheryl Today, appearing on behalf of counsel for plaintiff. On this one, it looks like the default judgment package was rejected on 10-3 for failure to pay sanctions. I was able to reach their attorney service, and she paid these sanctions this morning, I've been told. So at this time, we would request additional time for them to resubmit default package.
Very well. We show the sanctions were paid this morning. I'll continue the matter 30 days to November 19, 2019 for the, I better continue at 60 days.
That might not be a bad idea.
I'll continue at 45.
That's a good reasonable compromise.
Good. December 2nd, 2019 for OSC rate status of default judgment after payment of sanctions.
Very good. We will do notice. Thank you.
Okay. Okay. All right, I have a court call appearance on number 11 on December on Department 16's calendar. Riviera Finance of Texas, Inc. versus Organic Bottle Works, Inc. Counsel appointed.
Your Honor, this is the court collaborator. Counsel's line got disconnected, but he is still being processed now by one of our agents. Can we place the matter on second call?
Yes. Feel free to interrupt when counsel's on the phone. Can you do that? Operator?
Yes, Your Honor.
When counsel gets on the phone, when counsel's on the phone, feel free to interrupt us and let us know he's back. Otherwise, we'll never know.
Yes, Your Honor. I will.
Okay. Thank you.
Excuse me, Your Honor. He is now online.
Okay, Mr. I don't know the name. The firm of, the case of Riviera Finance of Texas, Inc. versus Greenberg.
Yes, Your Honor. This is James Felton on behalf of the plaintiff. I apologize. I was on the phone and somehow the line went busy, and so I had to call back in.
We continued this from July the 12th. We gave you a very lengthy continuance to submit a default judgment packet. You haven't received it. Is there any reason I shouldn't impose sanctions for your lack of diligence?
Yeah, there is, Your Honor, because after the first bankruptcy was filed, the second bankruptcy was filed. Apparently about a week later, I did file a declaration on Monday indicating all of this, and so we were unable to file the default package because of the filing of the second bankruptcy.
Oh, I wasn't aware of the bankruptcy.
Oh, understood. However, the second bankruptcy was just dismissed effective as of October 18th. It was dismissed on October 3rd with an effective date of October 18th. So I can't do it today, but at least at the end of this week or next week, you can submit the default package to the court, and I'm happy for the court to set a relatively short schedule for us to do it. It's already been in the works.
Very well. This is Judge Barry Plotkin. I sit in Department 17, and I'm calling Judge Poncin's calendar in Department 16 because she's unavailable. But it'll be back in Department 16 when it comes back. All right, so we'll show the following, that two bankruptcies have been filed delaying the matter. The second bankruptcy was dismissed October the 18th. Counsel is now going to submit a default judgment packet. And I'll, how long do you need to do that?
2 weeks, Your Honor.
Continue the matter. It takes our clerk forever to process these default judgments these days, so I'll continue it to December the 16th, 2019. And hopefully we'll have your default judgment packet back by then.
Understood, Your Honor. We'll provide notice, and thank you very much for the courtesy.
You're welcome. I'm going to skip back and keep my promise to counsel. Is counsel back on court call on Alaska Federal Credit Union versus Cotero? Did he make
Your Honor, this is plaintiff for Alaska.
All right, and then we have defendant's counsel here. Oh, I'm on the wrong case. Sorry. I'm on the wrong case. I'm going to take your case in a moment. Wait a minute. Is your case... Oh, Arturo Cotero. Come to the table. I might as well take it while I have it. So I need... This is Department 17. I don't know what number it is. Number 25. Counsel for Alaska Federal, your name? Your appearance?
Sam Lemmy.
And you're...
Yeah.
Okay, and then I have before me, there are two defendants, Arturo Cotero and John Jones. What's your name?
My name is Arturo Cotero.
Okay, be seated, Mr. Cotero. I have a motion to set aside a judgment. I'm going to give you a tentative ruling on the motion. I've read your motion. Did you have a paralegal prepare this?
Yes.
All right. I read this, but let me review your declaration again. Let me see what you wrote in the declaration. You had an account with Alaska Federal?
It was finance. It was a finance company for a vehicle.
Mm-hmm. And at some point you stopped making the payments?
Well, what happened was I got laid off from a job, and
I know, but you stopped making the payments.
yeah, they recalled the vehicle.
Right. But at that time you probably owed more than the vehicle was worth.
No, I owe less than what the vehicle was worth.
I beg your pardon?
I owe less.
You believe you owed less than the...
No, I knew I owed less because I could have sold it. I should have sold it, but they took it. Because I was trying to keep it. That was my form of transportation at that time.
Let me read your declaration. Who prepared this declaration for you?
A paralegal.
You don't deny that you lived at the residence address.
I don't live there no more. I haven't been
You
living
don't, in your declaration, you didn't deny it. At the time of service, you conceded that you lived at that address.
For what service?
The service of the summons and complaint.
I didn't receive anything.
I understand, but you lived there.
I didn't receive anything though.
All right, I'm not going to get drawn into an argument with you. You lived at the location, whether you received it or not. Correct?
Correct.
Thank you. And you seem to fit the description of the person who was served.
Oh no. Read it.
I did read it.
They missed the most important part.
What did they miss?
I wear glasses.
In giving physical descriptions.
And I'm not 5'6". I appear to be taller than you.
Well, it says like 5'6" to 5'10" or 5'6" to 6 feet. They're always these. physical descriptions are, remember, somebody's standing in a doorway and someone's standing outside, and they give very general physical descriptions. 5'6" to 6 feet tall, 180 to 200 pounds, 31 to 35 years old. I mean, that fits your description.
No, not at all.
Well, we disagree, sir.
Where I was residing, it was 2 units, 2-unit complex.
Well, that's not in your declaration. The summons complaint was served by a registered process server. The tentative ruling, I appreciate your argument, is to deny your motion on the grounds that your declaration has not overcome the presumption that is created by Evidence Code Section 647, that when a summons complaint is served by a registered process server, the facts are presumed to be true unless properly rebutted. But the defendant was served at your address in Whittier according to the process server, and it was a correct address. Letters were sent to, you sent letters to the plaintiff after the service of the summons and complaint, and even after entry of default. You sent them letters.
I didn't even know who this company was. Well, Alaska, I don't know.
You sent them letters.
Yeah, stop sending me those letters, because I don't know what company was trying to collect from me. I don't know who they are. When I spoke to Alaska said, you know what, you don't know nothing. So they even sent me a proof that I have a 0 balance with them. So they sold the vehicle.
Did you read the reply to your motion?
No.
I mean, did you read the opposition to your motion?
No.
Why didn't you read it? It's got some good stuff in there.
What does it have?
A good argument why your motion should be denied.
What does it read?
You want me to read it to you, or you weren't capable of reading it? It was mailed to you.
I don't live there no more.
Let's see where it was mailed. Where was it mailed, counsel?
Our motion?
Your motion, or your opposition to his motion. Where did you mail it? Well, here it is.
We mailed it to 7949 Washington Avenue, Whittier, California.
I don't live there no more.
You don't live there?
No.
What address did you put on your motion?
13502 Whittier Boulevard, Suite H.
Let me find it. Yeah, you mailed it to the wrong address, counsel. His paper shows that he lived at 13502 Whittier Boulevard in Whittier. So I'm going to continue this so you can send him your opposition and he can submit a reply. But he's kind of in the dark about what's going on here. Is that fair?
He has gotten plenty of notices, but
well, he didn't get notice of this. He didn't get your opposition to his motion, which is the most important document that he needs right now. And right on his papers is his current address, 13502 Whittier Boulevard, number H307 in Whittier. And you sent it to the address where he was originally served with a summons and complaint. Oh, wait a minute. Wait a minute. No, I'm looking at the original summons and complaint. Let's see where you mailed it. I was looking at the original summons. Where did you mail the motion to?
I believe the same
address.
The same address as the.
As what?
Yeah. That's the complaint.
which we believe was his address on file because he was sending mail from there.
No, his motion, you have to send the opposition to the address where the motion was served. But I don't see your proof of service of your motion, of your opposition to the motion.
Yeah. Let's see here. So we did proof of service by mail on October 2nd.
To where?
To 7949 Washington Avenue.
Right, that's not the address on his motion. So I'm going to continue this so you can send him your opposition.
Okay.
Okay. So we're going to show that the opposition to the motion was sent to the wrong address. And send it to the address on his address of record on his motion to set aside the default. And then read this in detail, and you'll understand. I understand your confusion now.
Yeah.
And then you can file a reply. So I'll order that the motion be served within the next 10 days. The opposition to the motion be served within the next 10 days. And the reply be filed within the next 30 days. And I'll continue the matter 60 days, December 16th in this court at 8:30. And then you should have all the paperwork so you'll know what the plaintiff's position is, all right? Okay? Okay,
Okay, Your Honor. Thank you.
Okay, thank you. You got the dates?
Yeah, December 16th, right?
Yeah. Then you can file a reply.
Okay. Yeah, because I have no idea what's going on.
Okay.
Okay, thank you.
All right.
Thank you, Your Honor.
Yeah. All right. Is counsel on the phone on Julius Brown versus Ontario Police Department?
Yes, Your Honor. I'm back on now.
Okay, counsel, come to the table. Okay, there's going to be a dead phone line for a while because I'm going to be rereading the motion, and I have notes on it, but the notes don't help me without rereading it, so I can address your concerns. So let me start with the complaint. Your name again, could I get the plaintiff's counsel's appearance?
Sure. It's Scott Humphrey on behalf of plaintiff, Julius Brown.
I have a document entitled Claim of Interest in Seized Property and Forfeiture Contestment, filed October 15, 2018. Let me read it. It simply consists of one paragraph. It's not a complaint as such. It's a claim for return of property. Is there a forfeiture proceeding pending?
I wouldn't, operators probably wouldn't know, the DEA, took this.
The DEA took the money?
Yeah, and we've notified, plaintiff of this, well, we've notified plaintiff's counsel and the DEA
Right.
and whoever handles, whether it's the,
Okay.
the state attorney or whoever does that, has notified of.
All right. Counsel, you never received a notice of forfeiture proceedings?
No, I haven't received any sort of notice of.
I mean, your client hasn't?
So that's.
Your client never received a forfeiture notice?
No, he's never received a forfeiture notice, number one.
Let me look at the demur.
You can actually, okay.
Go ahead. You can actually what?
But I may be able to sort of short change some of this, or if you want, Your Honor, I can kind of give you the scope of what's going on here. I have been informed that the DEA is who apparently has the money now. I've still never been sent anything by defense counsel or by the defendant themselves, even though I've requested it, at least from defendant, not from defense counsel, showing that the money was actually turned over to the DEA. They gave me some telephone numbers of the people who were, and names of the people at the DEA I was supposed to deal with. The telephone numbers were actually disconnected. So I don't know what's going on over there.
Well, this isn't helping me very much.
What I was going to say, Your Honor, is assuming that the DEA has the money, then I believe they are the proper party, and I should be amending to have the DEA as the defendant in this case. But I just want to make sure that it's the DEA that has the money, and if the DEA is not going to claim somehow that, well, we never got the money, it's still over there at the police department.
All right, let me review this, and then I'm going to tell you what I think is wrong with your legal theory. Give me
Sure.
Give me a moment. This might have all been made unnecessary had you responded to defense counsel's meet and confer endeavors. She tried to reach you 3 different times to discuss this, which was required on a demur, and you never responded. Any comment?
My only comment to that, Your Honor, is that we did actually exchange some emails on the issue, so.
That was just last Friday, Your Honor.
Yeah, that's a little late. The idea is to exchange it in time to correct the action if it needs to be corrected. Essentially, let me summarize the court's position in our argument. Essentially, the defendant or respondent claims that there are several defects in the petition that's been filed. One is a lack of standing, which I'll get to in a moment. The claim fails to state facts sufficient to constitute any wrongdoing on the part of OPD. But the claim is uncertain, ambiguous, and unintelligible. And here's the court's analysis. I reviewed this with one of our legal research attorneys after conducting some independent research. And for the purpose of the demur, I think the defendant has barely qualified to state a claim based on standing based on the fact that even though he alleges that the property seized belonged to his, well, the property, meaning the cash, not the suitcase, belonged to his girlfriend, but in the claim he alleges the suitcase in which the money was held was his and the cash was entrusted to him in his possession at the time of the seizure. And based on those facts, I think he probably has barely stated a claim for standing. But that's not the major problem. The major problem is the failing to state a cause of action. And there's some cases I'm going to cite that I want you to write down because you're going to need to look at them. There has to be some valid cause of action alleged that will stand up against a general demurrer. And I'm not sure that's been done in this case. It is true that the right to retain or to regain possession of one's property is a substantial right, and continued official retention of legal property with no further criminal action pending does violate the owner's due process rights. And I have citations if you need them. So there are substantial due process issues and whether the petitioner has been deprived of due process of law. There's case law that stands with the proposition, and this is a good part for the claimant, but it gets worse. But there is law indicating that the police can't retain a person's property with running afoul of basic constitutional considerations, particularly the 14th Amendment of the United States Constitution. However, I have concluded the following, and I can give you the case law citations so you can look at them. Mandate is the proper means of compelling the return of property illegally seized. Mandate is the only proper means of compelling the return of property seized. The role a police department plays with respect to seized property is primarily one of custodian for the court, and that's a quote, even as to property not yet offered or received into evidence in a contemplated prosecution, and judicial control still exists. And the cases I'm going to cite to you that you want to look at are Flack versus Municipal Court, 66 Cal 2nd, 981, at page 985, a 1967 case. Corno, Inc. versus Municipal Court, 33 Calat 3rd, 122, footnote 2, a 1973 case. And City of Garden Grove I cited it previously, so I have to go back to find it. City of Garden Grove versus Superior Court, 157 Calat 4th, 355, at pages 386 and 387. Because the, quote, claim for interest filed by Brown as not the proper vehicle for return of property illegally seized, the court is inclined to sustain and demur to the claim of interest. The question is whether leave to amend should be granted. In light of the court's decision, which is based on a theory not raised by either party, I'm going to grant leave to amend, but you can't amend this to allege mandate. You have to file a separate claim for mandate. But I'll grant leave to amend just because the plaintiff is unaware of the theory on which the court was going to rule. And I'll grant 30 days leave to amend. That's the tentative ruling. Does the government wish to be heard?
Yes, John, if you don't mind.
Sure.
My concern, I accepted that leave to amend might be granted just because this is the first demur. However, my concern is that there will now be this complaint hanging out there, really that my client has no part in, and also there will be now a writ of mandate that will be filed in a separate action, so we'll have all these actions outlined. I would request that we dismiss this case without prejudice, and perhaps you can file the writ of mandate and go that route.
All right, plaintiff? You wish to be heard?
Sure, Your Honor. No, we would certainly like leave to amend on this in this case, and part of the reason for that is that just a practical matter, and I will certainly take a look at the cases that were cited by the court along these lines. And if we need to file a separate writ of mandate action, we will. But I think there probably is a way to still assert what we need to assert in this case.
I'm going to grant leave to amend. If he doesn't properly amend it, it's going to be dismissed, and he can file his mandate action if he feels it's appropriate. So the ruling is as follows. Whose case is this? Our case. Here's the ruling. The court will sustain the demur with 30 days leave to amend. However, the court believes that the proper remedy for plaintiff to pursue is a writ of mandate, and this complaint can't be amended to state a writ of mandate. A writ has to be separately filed. I'll continue the matter. Did I indicate 30 days leave to amend? All right. I'll continue the matter 90 days. Thursday, January 16, 2020. November 13th TSC should be stricken. And by that time, we should have everything sorted out. If you do file another amended complaint and you get a meet and confer communication from defendant, you're to respond to it promptly, or I'm going to impose sanctions.
I will, Your Honor.
All right. I'm going to ask defendant to give notice of ruling, so it's clear.
I will do that, Your Honor.
All right. Okay, folks, thank you very much.
Thank you.
Thank you for your patience this morning.
Thank you.
All right.
Okay, thank you, Your Honor.
All right. It is late and I need to give myself a break, but I'm just going to we just have a few more, then we'll take a break. Clerk, call Mallory. Okay, number 17 on court call. Somebody's been waiting a long time. LBS Financial versus Valdez.
Good morning, Your Honor. Here's Tamara appearing on behalf of LBS Financial.
Yeah, sorry for the long wait. It probably would have been cheaper in the long run to hire a special appearance attorney, but you didn't know you'd have to wait so long.
That's okay, Your Honor.
There's a BK that's still pending as far as I can tell, unless you know otherwise.
No, Your Honor, we checked the docket. The bankruptcy is still outstanding, so we asked for a 3 to 6 month continuance.
All right. Continued 150 days to March 16, 2020. Minute order to reflect BK is still pending. Counsel to file a declaration 10 days prior to the hearing. Raise status of bankruptcy. And again, my sincere apologies for keeping you on the phone for an hour and a half.
That's okay, Your Honor. Can I get that date again, Your Honor?
Yeah, it's March 16, 2020.
Thank you, Your Honor.
Okay, thank you. You're excused.
Thank you.
All right, number 3, State Farm versus Gustavo Mota Ayon.
Good morning, Your Honor. This is Andrew Doerr on court call for plaintiff State Farm.
Good morning, Your Honor. Janine Jeffrey on court call for the defendant.
Ms. Jeffrey, okay, could I get the spelling of counsel's last name on plaintiff's, for plaintiff?
Yes, Your Honor. It's Doerr, spelled D-O-R-R.
Oh. First name?
Andrew?
Andrew.
A-N-D.
Okay, we got that.
Yeah.
Usual spelling. All right. The matter was last on calendar August 30, a stipulation, an order for settlement was submitted for review. And let's see what's happened since then. Plaintiff filed a brief. Oh, is this the one where I was concerned about Green Tree? Yeah.
Yeah.
Yes, it is, Your Honor.
Okay. And it was not shot to, but I've been gone for 2 weeks and was not alerted to this filing.
Your Honor, just for clarification, this is, I represent the defendant, and I did not receive notice of the court's order regarding the request for further briefing.
Oh.
And I didn't receive plaintiff's request, I didn't receive plaintiff's brief until Monday when I first learned that this was even on calendar, which is why you don't have anything from me.
Oh. So you want some time to file something?
I would. I think that's an important issue.
It is. By the way, there are a number of recent cases. I didn't take the time to tell you about them, but if you shepherdize, well, I did talk about. Let's see, did I didn't mention any others.
You did. You cited the most recent one, which is out of the Second Circuit.
Oh, red and white distribution.
Or the Second District, I'm sorry.
I just didn't give you the site on. Yeah, that was just decided August 9th. That has a much more detailed recitation of the facts and the law. So, yeah, do read red and white distribution. And counsel, I'm sorry, but I am going to give defendant an opportunity to respond. And how much time would you like?
I would think maybe till I can file an opposition by the 25th.
Oh, I'll give you more than that if you need it, but
okay.
All right, file it by by the, yeah, you can file it by the 25th. And then any reply to be filed by November the 4th, or make it, I'm going to give you a little longer because I'm not, I just worked every 2 weeks. So I won't be back here until November the 18th. So let's change the dates again, I'm sorry. Opposition by October 30, reply by November 12, hearing November the 19th. And please file them directly in Department 17. Don't file them in the clerk's office, or I'm never going to see them. File them directly in Department 17. And the matter will be referred to legal research, because I want to get a research memo on it. And
will do.
notice waive.
Notice waive.
Yes, Your Honor.
All right, I'm going to change
clear,
one date.
have you?
I'm going to change one date on you, okay? We'll change November 19.
Okay.
We'll change November 19 hearing to November 21. All right.
All right.
Okay,
thank you, Your Honor. I just have one question.
Please.
Did you receive our brief, or would you like it to refile?
Well, let me see what I have here. Yeah, it's filed. We got it.
Okay.
Okay.
Thank you, Your Honor.
Oh, and then you can, did I give you a date to file a reply? Okay, I did. All right.
You did.
Yes, you did.
Okay, all right. Thank you, folks. Sorry to keep you waiting.
All right, thank you.
You're welcome. Okay, I'm going to see this here, and then we're going to take a short recess. And I'm going to do these name changes, because they don't take very long. Come forward when your name is called. Numbers 22 and 23. And Department 17's calendar. 23 is the claimant exemption. All right, Rosa Tiba, come to the table. Oh, it's about Rosa Tiba. It's not filed by Rose Tiba. All right, who is the petitioner in this case? Are you mother?
Yes.
You're the mother. Does she not speak English?
No, she speaks little.
What language does she speak?
Arabic.
Oh. Are you Rose?
Yes.
How old are you, Rose? How old? Who is Rose? Oh, you're Rose.
Yes.
Okay, I need your name.
Russell.
Whose name is being changed? Rose's name?
Yes.
Oh. You're just interpreting. I finally got it. All right. Okay, so let's get daughter's full name.
Russell and Ansari.
Louder.
Russell Ansari.
Spell the name.
Rusul. That's first name.
Rusul?
Yes.
Last name?
Last name is Alanaskary.
All right, almost sorry.
Do you promise to translate Arabic to English and English to Arabic to the best of your ability?
Yes.
Do you solemnly state the testimony you shall give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
right, thank you. You may be seated. I don't seem to have a decree. Hmm? Oh. You've not published the order to show cause?
Yes, I need more time.
Okay, you need more time?
Yes.
All right, how much time do you need?
1 month.
Sure. It takes 4 weeks to publish it,
Yes.
so you need more than 1 month.
Yes.
All right, I'll continue the matter to December the 16th in this court at 8:30. But you get it published right away. Okay?
December 16th.
They gave you a list of papers that will publish. You have to pay them for. Okay, thank you. We'll see you back here.
Thank you.
All right, I think I'm going to hold this one over until after our break. Christopher Beesenson?
Yes, Your Honor.
Okay, I'm going to take a recess for 20 minutes.
Okay.
And then this is a bank levy?
Yes, sir.
Okay. Then we'll hear it. Okay, we'll see who's here. We'll see who's here. Okay, number 27. Okay. Perez versus De La Rosa. Dismissed without prejudice. Number 28. I don't have the calendar page in front of me. Okay. All right. Mr. Alvarez, you're present?
Present right here, sir.
Okay,
Good morning.
I'll get to you in a few minutes.
All right. Thank you.
You're welcome. Okay. Gustavo Garcia and Mark Hernandez. Take you in just a few moments. Okay. TD Bank USA versus Geary.
Call to check-ins.
$100 monetary sanction failing to appear. Strike that. A dismissal was rejected on August 1, 2019. Needed to sign an original document. This case is now a year and a half old. I'm going to dismiss it for lack of prosecution without prejudice. Number 7 of Department 16 calendar.
Call to check-ins.
Portfolio versus Hernandez.
The farmer did not check in on this one.
He's still around. Let's see if we can get hold of Mr. Farmer, because I know I want to do something with this.
It does have a
Yeah.
Wow.
No, what I'll do is I'll impose and stay a $100 monetary sanction for failing to appear and a $50 monetary sanction for failing to serve. And I'll continue the matter. I'm going to put it over before the April 15th, 2020 hearing to Monday, December 2nd, 2019. Plaintiff to file a declaration 10 days prior to the hearing for any sanctions and failure to serve. Okay. We'll be in recess for 20 minutes. Oh, there's an party motion? Oh. All right. Well, somebody's been waiting a long time.
Me? Oh.
Spencer versus Bill and WAG, Inc.
Good morning, Bill.
Your name?
Erica Springford.
I'm going to have to read your papers, Ms. Spencer. They're very lengthy.
I don't know if that's a good or a bad thing.
I beg your pardon?
I don't know if that's a good or a bad thing.
It's not good for me because it's going to take me forever to read this.
Okay.
I mean, my goodness.
It's
Oh, I see there are multiple declarations.
Right. It is related to pending litigation. So.
It is?
Yes, sir. But I can let you know basically the underlying premise of my ex parte motion today with regard to the defendant, Bill and WAG, Inc. In general, my vehicle was towed on October 2nd, and I am seeking to bring a civil action for conversion pursuant to their towing my vehicle. It was at the direction of Ontario law enforcement, and the way in which it is related to pending litigation is because...
To what?
It's related to pending ongoing litigation because on my theory, my case theory is that, and my, in addition to my declaration and the pleadings that already exist that I've attached to the ex parte application, they demonstrate how the direction for the defendant to tow the vehicle was pursuant, it was under the color of authority. It is pursuant to ongoing stalking and harassment that has been going on.
Stalking and harassment?
Stalking and harassment.
By whom?
By the government.
By the government?
By the government, which is thoroughly documented.
Who is the government? What do you mean the government?
The government. So.
What government?
The government. I'm sorry.
Well, there's government on city, state, county.
Correct.
Locals, federal.
Correct. So as far as
which government?
So as far as my case goes, as far as my documentation goes, what I have done is I've documented the pattern of conduct, which is what California.
Which government agency?
Right. So I am getting to an answer for your question.
I'm waiting.
There are, as far as what I've documented, am I able to identify the person that is flying these aircrafts? No, I'm not. Of course not. Am I able?
Flying aircraft?
Yes. Yes.
Are you a law student?
I am. No, I'm actually formally licensed to practice law.
You what?
Formally licensed to practice law.
Formally licensed to practice?
I mean, I still have a license, but pursuant to what I've been experiencing, it has had a catastrophic effect on every facet of my life, including my career, including my livelihood where I live. I'm currently an indigent, homeless. So.
Did you give notice?
Yes.
Of this hearing?
Yes.
Who did you give it to?
I called on October, and that's in my declaration as well. I called on October 13th. I called the defendant. I spoke with Chelsea.
Bill and WAG?
Yes. I called them at their number that they published to the public. I spoke with Chelsea. I let her know about this hearing that will be today in this department. And I also through the sheriff's office who provides notice for I'm a fee waiver recipient, and they sent the papers yesterday, which was as reasonably soon as possible as I could have them sent to them.
Today is October the 16th, right?
Correct. So that was yesterday.
Your motion is to shorten time to hear.
An action that was filed on Friday. Yes.
To hear the October 11th, 2007.
October 11th.
What do you want to shorten time to hear? What?
Because the defense.
No, to hear what?
Oh, to hear my action that I filed on October 11th.
To hear the trial?
To have a hearing for it. The initial date is set for April 13th. My rights pursuant to my personal property will already be permanently altered by that date, and it will be moot.
What do you want? What kind of hearing do you want?
What I want is for the court to address the issue sooner than later. The defendant is a tow company. It has a possessory.
So what kind of hearing do you want me to set?
What kind of hearing?
Yeah.
In my opinion, as far as what I've laid out with regard to the pleadings and the complaint, it's pretty laid out what my position is.
I'm going to need a case printer on something. I just need to see the history.
And actually, a lot of the history is attached to it in the exhibit.
Whose case is this?
16 PONCIN.
Yeah. Yeah, okay, we're going to take a recess.
Okay.
And I'm going to
read it?
I'm going to attempt to read it, but I want to get some of the history of what's been filed, okay?
All right, and you didn't allow me to answer a question with regard to the government, Judge?
Yeah.
Okay, so you asked me about the government. As far as what I know, I am not aware of the specific parties who are flying the aircrafts or actually...
What do you mean flying aircrafts? What do flying aircrafts have to do with unlawfully towing your vehicle?
Based on, and maybe when you read it, you'll be more informed as to what my allegations are. But I have alleged in my original petition from September 12th that I filed in the other case, which is related to this one, state stalking. And
where is that case set?
Where is it?
Yeah, what court?
This court, Judge.
In this court?
That's correct.
16? And who are the parties in that case? You and who?
I have initiated suit against the state of California.
The state?
The state.
You say you're formerly an attorney?
As far as being accredited, you have to pay your fees. I haven't been able to pay my fees. That's the only reason why.
Did you go to law school?
Absolutely. That's how I got a license.
Where did you go to law school?
I'm not sure how that is relevant, but I went to Whittier Law School.
It's not really relevant. I'm just curious.
Okay. Can I ask why?
I'm just curious where you went to law school, how much training you have.
Okay. With regard to my application that I wrote, it should be easily understood.
Okay.
And perhaps we can have a more fruitful exchange after you read it.
Okay. Agreed.
Okay. Thank you.
Right now we're going to take a 20-minute recess, so I'll have you guys exit the courtroom and just wait along where the judges are, so 16 and 17, and then we'll
I don't know what that means, but everyone will know how much of a terrific speaker I am.
I'm just tripping, and then I forgot why you usually say that. It's funny how a lot of white people think that us black and Mexican people don't know our laws.
Well, you know what?
with regard to what that judge was just asking me as far as the government and all that, what's funny is if it was any other crime, say like a burglary or a robbery or something,
I know where you're getting at.
I wouldn't get the same question. But because it's being alleged against the government, and it is an extraordinary allegation, I get it. But it ain't my job to speak on behalf of the government. It's my job to give you the proof, because I know what's going on.
Yeah.
That's all I got to do. But I have to entertain asinine questions like that and do it with a straight face. But that's fine, because I'm prepared for what I'm coming up against. And I know exactly what I'm coming up against, and it's nothing unfair.
Yeah.
Absolutely nothing unfair. You think I'm ignorant? I know exactly what I'm
When you
coming up
say
against.
flying things, you're talking about the drones, huh?
I'm not talking about drones. I'm talking about the very same helicopters and planes that all of you people see, and you act like you don't see it. This is not Vietnam.
No, I know.
Okay? We don't live on the airport. We don't.
No,
And I don't care how many airports there are around here. All the airplanes that are flying around here, I've never seen that in my life. Never seen it in my life. And I've flown in different countries. I've been on airplanes. I've lived in California. This is different, right? The government has been becoming increasingly aggressive. And what I see is everybody walking around like they don't hear the helicopters circling around the building.
Yeah,
That's how I know.
Yeah.
Everyone will act like, no, you can't claim I'm crazy because I got the proof. You can't claim I'm crazy. So, I really don't care. I don't care about people walking around with their cell phones. All you're doing is you're documenting me prosecuting you in court. That's all you're watching. That's what you're watching. Because it's going to happen. If I have to go over stupid questions by a judicial officer in order to do so, so be it. Whatever. My case is my case.
I feel like the law's too ignorant now.
No, the law's not ignorant.
I feel like it is in many
Those who
different
practice
ways.
law are corrupt. That's what it is. The law is the law. And it's very powerful.
But they don't follow
The
it though.
point is it's in whose hands it is.
Yeah, they don't follow it.
Well, the law is very potent if you know it. You know what to do with it.
You're gonna sue someone who doesn't exist anymore either.
No, it doesn't.
And if it does,
I'm gonna tell you what the system is. The system is designed to oppress those who don't know any better, who don't know their rights, who don't have, even if you know your rights, you don't have the ability to enforce them, or maybe the intestinal fortitude. Some people are scared. Some people are intimidated. This is something that's designed to silence and oppress. And I'll be damned. Not me. Not me. So pass that on.
Have a good day.
Yeah, you too. Listen to that. Watch that.
Sí, pero tuvo que ir los tres más horas por la reta afuera. Le dije, es que decime cuánto lo estás cobrando por hacer el divorcio. Le dije, 200. Le dije, 200. Y me dijo, ¿cuánto está cobrando? Le dije, $1000. Le dije, ¿pero que está bien eso? Le dije, no, te vamos a dar como un cuarto de lana. Ya está todo ahí. Mucho dinero. ¿Ves?
Hello?
Mira, ahí tiene su estudio, lo que está haciendo, ¿ves?
Es que le llamaron porque estaba hablando su declaración de impuestos y
No, empieces tú, no.
mira, eso fue eso. Estamos, ayer fui al departamento de policía, pero me dijeron que están detectives
No, el problema es que él presume su estudio, ¿me entiendes? Y su estudio vale mierda, porque como se llama, no está haciendo lo que hizo pues para tener dinero. No está siendo honesto. El estudio era un ratero,
no,
¿me
sí, por
entiendes?
eso. No, sí, por eso estoy haciendo todos los papeleos con el security guard y todo para
No
que
tienes ni
cuando
carro.
se presente uno aquí, tengo los papeles.
Pero,
Los
pues está
exámenes,
bien,
todas las cosas.
$200. Y
Ya recibí los
ella está
códigos,
haciendo, como
traje
dijo ella,
todo
yo estoy
aquí.
haciendo todo el trabajo, estoy haciendo todo.
Ya que me salga de aquí. Voy a quitar esta, no, ya se enojó, todo mi
Ella
mamá.
me dijo lo que me está cobrando $200 por hacerme el divorcio y estudiante lo que me está cobrando el viejo. No, pero no lo voy a decir nada, pues no creo que no está problemas con esto. No, pero lo que voy a hacer, ya le dije a ella, dile que el abogado me va a hacer le dije que el abogado que tenía antes me hace el divorcio, y yo le voy a decir lo mismo, pero que me va a cobrar más barato el abogado, pues me acuerdo que unos $500 para tener el divorcio. Lo que le voy a decir. Pero no jugarle el juego que es como le dije aquí en Fontana que me quiere cobrar por el carro. ¿Ya sabes cómo llegar ahí? Más conocido. $2,000, ¿qué piensas? Pues le urge, pues me está preguntando cuánto es el papeleo, y le dije, no, pues no lo voy a hacer. ¿De cuánto era el divorcio? De 300, porque cobró la muchacha 200, 300, 400, le subieron 1,200. Eso no está bien, eso es lo que es, no se hace.
Hermana, buenos días.
Bien. Es que te digo, por eso es que unos chingadillos pues, pero eso no es problema, pero te hizo algo mal cuando te digo que te le está echando encima ¿cómo se llama allá en la misionería? Hizo algo mal en la señora. Pero es que como te estoy diciendo de gritón, pues, y se cree muy chingón acá, pero...
El lunes fui para... Ya ves que les quería verla, pero los otros meses no me quería ver. Yo fui para allá y me estuvo explicando. Y dice que va a ir, me dio una cita para el 21. Entonces me quedé para ver si dice que pueden encapsularlo, ¿no? Para que no... pero dice que todo está bien, está todo recién, se puede hacer. Entonces, y sí, oiga, y aquí ando
Pues me dijo,
haciendo una cosa para vecinos,
me cobran tan bien barato para ir. poquito más y
Pero
después
no,
le das
no me
50.
quedaba, han dado vuelta, hermano, viera cómo
Tú
bendito
fuiste
Dios
a la
por allá
cámara
ando
de
de
gente,
que
entonces ok, voy a cobrar.
ando vuelta en vuelta, la ficha manda, ficha
Si estás
vuelve
cobrando,
y luego
si estás
todo
cobrando
así.
los $100 y tú le quieres dar
Ahí ando,
$100
hermano.
a él o $50, cobras los 150 para que tú le des 50 dólares.
Hermano.
No dejes que tu
Ore,
pequeño te esté robando a ti.
ore
Eso es
mucho,
lo
hermano,
bueno.
por todo.
Después nadie va a querer ir contigo.
Mejor hija,
Ya te está diciendo
porque sí
verdad.
le oro todo lo que dice el Señor. Así de que,
Te estoy diciendo que cómo se va a
sí,
estar.
ahí ando, hermano, ahí ando echándole ganas. Ahorita, ahí andamos, bien, espero que vienen bendiciones, todos los sufrimientos van a venir bendiciones. Y aquí ando, hermano, ahorita, digo, ahorita venimos a hablar, pero bueno, nos
¿Qué
juntamos para
pasó?
poner. ¿Mande? Bien, hermano, lo llevé a la escuela temprano, ya me vine para las 11. Lo llevé a las 6:15, ya me vine para acá a las 6:30, abría, ¿no? Ya me llegué. Ya, todo bien.
No, es un juez que está ahí. Un señor. No, hombre.
Sí, hermano, con el poder de todo, todo se puede. Bien. Ok, hermano. Sí. No, al contrario, claro que sí. Ok. Claro, ok, dale. No,
Sí, está bien. Me dijo que ya me dijo, estoy cobrando $200 por día. Sí, él me está cobrando más. Voy a hacer ganas de eso. No, él le va a los $200 a él y esto está conmigo. ¿Entiendes? Conmigo que sea de persona él, una persona mala. Conmigo que sea de persona él, una persona mala. ¿Entiendes? ¿Ves? Entonces, lo correcto es como sea lo correcto. Él me dice que no, yo hablo lo que yo digo, lo que siento, lo digo, ¿me entiendes? Y ya que él está haciendo a lo escondido.
Buenos días, ¿cómo está? ¿Cómo le ha ido? aquí estoy en la corte todavía. Ven a mirar el juez. Sí, hay varias personas. Sí, ya estoy aquí. Faltó una hoja que poner la edad de valente y una declaración para que me enviaran. Me dieron otras dos hojas. Aparte, nomás le eché una declaración corta. Que porque no quería mirar y me dijo que tenía por la
I'm glad the court is openly acknowledging that it is the criminal. It is. They are here doing the exact same thing, documented out on the street. Exact same thing.
450.
Tantamount to an open acknowledgement.
Pero a mí se mete la culpa si ha hablado conmigo, no me va a nada.
Right. Open acknowledgement at the justice center.
Okay, cualquier cosa tomo si no puedo hacer otra cosa, pues vas a para que se salgan rápido de ahí. A ver qué hacemos. Okay? Okay, bye. Buenos días, ¿cómo andamos? Aquí vine a poner la orden esa de detención para alguien aquí en la corte. Aquí está en la corte. A ver si usted tiene esa orden. Y ya no sé. Y más por eso es necesaria que los vayan a mandar a todos los pasantes.
Comprehensive corruption.
Si no, pues voy a pagar un abogado.
Bueno, ya trato de tener.
De que me la sacan, no que se quede ahí viviendo, cabrón. ¿Mande? Sí, pero te digo, que me hagan bien, porque pues, gente loca. ¿Ok? No, llegó solo. Ok, ya me están llamando aquí.
No sé cuánto dura aquí.
Yes, it's an hour. You come in, because you're here for the confidential hearing, right?
Okay.
So I'll probably have you go inside and I just have you.
Have these on? Los divorcios, jefe. Divorcio, le digo.
¿Estás divorciando?
Pero a mí me ayudaron hace un año aquí en San Bernardino, gratis. Vine a... Es un programa que hay aquí en la... Y me ayudaron gratis. No pagué más que el puro papeleo. Ni de volada me lo hicieron eso.
Sí, estaba con mi novia, me está ayudando una señora que nomás me está cobrando $200 y el señor que ¿cómo se dice? Me llevó, me está cobrando $1,000. Pero ahorita cuando salió me dijo, ¿cuánto me cobró el divorcio? 200, digo, ¿quieres saber cuánto me está cobrando tu amigo que me te llevó contigo? $1,000. Se encabronó la vida. Mucho dinero.
Más ahorita con esta crisis que hay ahorita.
Y el problema es que no estamos teniendo nada, ¿verdad? Vamos a firmar los dos, ¿entiendes?
Todos están de acuerdo.
Estamos de acuerdo, no estamos peleando por nada. ¿Y cómo se llama?
Unless they're trying to get your cardio.
Yes.
Right, of course. That's vital.
Porque yo sí mucho dinero, mija. Ya, le voy a pagar, pero ya me pagan $200 hace mucho para el divorcio y el abogado que tuvo me quería cobrar unos 1,500 más. Como dicen, no es porque se que tienen dinero, de verdad no es porque nada. Nomás que la gente, ¿cómo se llama? No debe ser así. ¿Entiendes? Ahorita me está diciendo que vamos a divorciar, me está diciendo porque necesita el dinero. La muchacha, ¿cómo se llama? Como ahorita como todo trabajo, que sabe que
Está ganando más él que ella.
pues también tiene la culpa ella, porque le dije, pues tiene
When the devil has been found out, he gets real sloppy. He doesn't even care the way it obviously looks anymore. It's just all out there. And it is all out there.
Entonces la culpa es, si usted no trae gente, yo te voy a pagar eso. Entonces como que sabes que tú te vas a mirar más cuando la gente te va a preguntar, vas a meter su mano, porque le dije, pues que ese es donde está conmigo. Yo no te voy a decir nada viejo ya.
Yo vengo a ponerle a una, o sea, también una amiga me dijo porque uno no se siente seguro, tiene miedo que...
There's an airplane right there.
Sí, cierto. Es que yo renté una casa, nomás que me vi en la situación de rentar un cuarto que viene, se lo rentó una pareja. Y le dije cuando estaban solos, no, se viene la zona cotón, le gritan, le humillan y tiene miedo él de que vayan a
I
golpear
just
un
need
día.
a lady, his current phone number, someone can add it on there so that they can search him.
Walking back and forth.
I'll talk to you later. I'll let you know how it goes after I'm done. Right here in the Justice Center. It is all out in the open. Go get your rounds. Don't you guys come back? Pathetic.
Y es lo que vengo a ponerle a Daniela porque ya no puede, no me cerraron el cuarto, llega a la escuela.
Yeah,
Hoy lo
ethical
reportó por
checklist
encima,
for the lunch.
voy a contestar cuando me vuelva para el trabajo. No se podía hacer, no
Or
viene
just leave it.
asustado y...
Keep it on. You're going to eat it. That's all. She's like, Missy, you over there with everything ready. I woke her up early.
No hay contratos o nada.
No, she wakes up, but then like she's like is ragging on everything. She don't want to do stuff anymore. Takes her a minute. She usually just wakes like at 10:54 a.m. Plane's flying up here on the 5th floor of the Justice Center. No.
Como yo tengo el reporte de policía que mi hijo ya está fuera.
This is the base of court. This is what it looks like. Yeah, so they did.
Hablé con la muchacha que me ayudó a llenar los papeles.
Wait, what's the score? You sending me code too?
No, ya, 1934.
Is that the coordinates? That's so weird.
Una fábrica parece que está haciendo dólares.
La cara esa.
2016 la custodia nueva para el día del padre. Y luego se necesita una fecha final para pagarlo. Nunca te los patrimonios. Yo mando planes. Tengo un
Just call me.
tengo un par de
Okay, I'll have all those for department 16 and 17 come back in.
All right, this, defense should come to the table.
Sure. Yes, it should.
You can be seated.
Be seated, okay.
One of the problems I'm having is you didn't separately attach a staple or clip or bind any of the documents. You just have a big, huge stack of documents.
It was bound by a clip.
It's not bound by anything, it's bound by a binder clip.
Yes.
So I can't tell where one document begins and one document ends.
There is an exhibit and an index.
The problem is I can't tell you're required.
There's an index of exhibits. Did you not see that?
All right. In addition to an index, you're required to tab the exhibits. So I can't tell what you've got here, but let me see if I can make sense of what you've done here. You filed a complaint on October 11,
right,
and you named Bill and Wags as defendants, right?
Yes.
Have you served the complaint on Bill and Wags?
I did. As soon as I filed it, it was served on the first day.
Who served it?
Sheriff's Office. I have not yet gotten the proof of service back from them, but it was done on Friday, the same day.
I don't have the proof of service.
Right.
So I don't show that you served Bill and Wags.
Well, I did initiate it. It was done on Friday, so.
You may have initiated it, but they haven't been served.
It hasn't been completed or probably not recorded as completed yet. That's correct.
That's right. So I can't grant this because they don't even have notice of the case. Until they're served, they don't have notice of the case. Secondly, I can't find any declaration that you gave Bill and Wags notice of today's hearing.
It's in the declaration. It's paragraph.
Yeah, you're gonna have to find it for me because.
Okay, so my
no, you're gonna have to find it for me.
Yeah.
Because I need the declaration that you served them.
It's right behind the application, actually. Do you want me to go
Well,
up there?
how do I know where the application begins and ends?
Do you want me to go up there?
Behind the application is Exhibit A, which is a petition for relief from the claims requirement filed September 12th.
Right, so contrary to what the court would like to
No, I
represent,
want.
it is on page 1 of the declaration.
Of your declaration?
Declaration, the heading is at the footing. It's all clearly organized, and it is clearly.
Tell me where it says you gave them notice of today's hearing. Read it to me, please.
Read it. It's at paragraph 2.
Just read it to me, please.
I'm getting to that, Judge. On Sunday, October 13th at 3:46, I called the defendant. The phone number at line 26, it says, on page 1, it says, I informed the woman, Chelsea, that there would be ex parte application, and that I would be submitting a request to order shortening of time to hear the action for conversion. I told her that the department was in F-16 at the San Bernardino Superior Court. That's at line 5. I gave her the address. That's at line 6.
You repeated the date?
I repeated the date. She would not answer as to whether she knew or anyone else knew that they had any intention to appear to oppose the application.
But you don't know if they've been served with a
What I know is that on Friday, October 11th, the same day that I filed the action for conversion, is the same day I went to the sheriff's office to
But
have
that doesn't mean that they served them.
That's correct. And
Okay,
time would
you come
require-
back with a proof of service, and I still can't consider it, because what you're asking me to do, if I understand you, is you want an order shortening time for the trial. Is that what you want?
I want the court to...
No, just tell me, do you want an order shortening time for the trial?
Effectively, yes.
I can't do that.
What I want is...
They have
for the
30
court
days to answer the complaint.
I understand that. So, may I make a complete statement, or do you want to continue to speak?
I prefer to give you direction.
Right. You
All
keep
right.
asking questions, and I want to respond, but then you
All right.
interrupt. So, I'll wait.
All right, this is not a question, this is a statement.
Go ahead.
They have 30 days to answer the complaint. I can't grant a ex parte application to shorten the trial before they answer the complaint. They have a right, now you have to put that down so you can listen.
No, I can do two things at once.
No, I want you to put it down, please.
I'm listening, and I need to take notes of what you're telling me that you cannot do, because I do not see it.
This is all being recorded, okay?
That's great.
Okay.
I need my own record.
All right. They're entitled to notice of the trial.
Correct.
Okay. They're entitled to 30 days to file an answer. Okay. They're entitled to conduct discovery.
I'm aware of all of that.
Okay. Then you know that's why I can't grant an order shortening time for trial.
I disagree.
Well, see, you said you want to talk, you want me to talk. So once I talk,
Thank you. You're welcome.
you can't interrupt me right in the middle, because I'm trying to tell you what is wrong with it. All right, so they haven't had a chance to do any of those three things, so I can't grant the order shortening the trial because it's premature. So you have to wait until, 1, they're served, 2, they file an answer, 3, they've conducted some discovery if they wish to, because I don't see any emergency here to set a trial date. When do you want the trial date?
You just said you see no emergency here?
When do you want the trial date?
I have laid out that
Just tell me when you want the trial.
I am laying out that there is an ongoing emergency based on my dispossession.
I want to know when you want the trial.
That placed me on the streets, Judge.
Okay,
and
listen.
Secondly,
I read it. Okay, stop.
For you
now
to
it's my
say
turn
that,
to talk.
no, for you to say that there is no emergency, that's factually incorrect.
Okay.
And I have satisfied the legal requirements for an ex parte.
All right. Let's
And
forget
you
the
are
emergency for a moment.
You can't forget the emergency. You're disregarding, quite flippant, if I might say so, Judge, with regard to my circumstances that affect my life. So I have satisfied the requirements for an ex parte, and contrary to what you're stating in the courtroom right now, I am able to file the application, and I have satisfied, and I have provided the affirmative factual proof that's needed in order to do so. I have satisfied as far as serving in the service of process, contrary to what you say, because the Sheriff's Office hasn't given me proof of service yet, does not mean that they haven't been served. And the fact that that formality hasn't been completed yet does not hinder me from filing my ex parte application.
When would you like the trial?
They are a tow company.
When would you like the
They
trial?
are inclined to sell my car any day, so as soon as possible, hence the application.
They have to give you notice of intent to...
And guess what? Pursuant to the stalking and harassment that law enforcement is engaged in, they're using an address that I have no access to. Any notice that they send, I will not receive. And guess what? The rules under the vehicle code that are applicable, under his possessory lien that he should not have, he can still go forward and transfer my personal property to a third party.
Right, let me interrupt you, please. Okay, you're required by court rules to put an address where you can be contacted by the court and by the other side.
I have.
Please? You've not done that. So the fact that you remain incommunicado because you put down no contact information.
Where? What are you speaking of?
On your paperwork. Under your name, you have to put your address.
I am a homeless indigent. I don't have
I understand that. But you put down a P.O. box You put down a friend's address?
I don't have that.
A relative?
I do not have that.
You don't have a friend or a
If
relative?
I had that, I would put
Okay.
that down.
Right. We can't contact you.
Exactly. I'm homeless, hence my emergency that you want to disregard.
In 29 years on the bench, I've never seen anybody that has no way of being contacted.
Okay.
There's somehow we can contact you.
I have never heard of a government stalking a citizen contrary to their constitutional rights.
That doesn't matter.
Yes, it does matter.
Right. You have a cell phone number, don't you?
No, I do not.
You said you have a cell phone.
I called by payphone, that's what I said. In my
You said you had a
declaration
cell
that you said you read.
You didn't say you had a cell phone?
I said that I recorded documentation of stalking. It's not an operating cell phone.
It's not an operating cell phone?
No.
All right. Your motion is denied.
On what grounds? And I'm shocked.
On all the grounds I've stated. Now, I'm not going to
You
repeat
stated things
them
that
again.
are not true, though.
All right.
You did.
You have a right to an appeal. You can appeal this denial of your right to seek an ex parte application. You apparently did properly give notice. I don't have a proof of service.
And you're saying that that's grounds for your not granting.
First of all, I don't see your complaint.
It's not attached to the ex
Just a
parte
moment.
application.
Let's see how it...
But that is part of the file.
Where's the complaint?
It's not filed. It's not attached to the application.
So I don't know what the complaint says.
You're stating a lot of reasons that are superficial for not granting my application.
Okay. All right.
But what I want to say is you stated because there is no proof of service, that's the reason why you can't grant my application, right?
That's one reason.
Okay. Well, that is an insufficient reason as far as the law that I understand it. As far as the ex parte goes, the ex parte application.
Okay, I'm not the Court of Appeal. You have to argue to the Court of Appeal.
No, but I'm going to let you know that you are erroneously and prejudicially denying my application on superficial grounds, just like the other court did. And it's no wonder, it's no mystery that the law enforcement of the government is engaged in the criminal conduct that it is. This is why, because it's being protected. You have no reason, really. I have satisfied notice, and not only that, I have met the requirements. There is an ongoing emergency, there is an imminent threat of injury, of permanent dispossession. He has a possessory lien over my vehicle based on stalking and information that law enforcement has they shouldn't have. It's an unlawful seizure. And they did it through the means of a third party. That is wrongful possession, that is conversion. And if the court does not act, I will be permanently dispossessed of my personal property. That is a cause of action, and that is actually grounds to grant this application, which you are intended not to do. So I want to get that on the record. I'm glad that you're recording it.
Right.
You are the second court that did so.
An ex parte application to advance the trial to an unknown date. What date do you want the trial?
As soon as the court would hear it.
Just give me a date, please.
It would be this month. But it's a tow company.
All right, the request to hear the trial this month is denied. That goes to the minute order. Is there a trial setting conference date?
It's set for April 13th.
Right now, he's just talking to them.
Well, there's no need to do that.
I don't think so, because you.
Okay, all right, thank you.
Rephrase.
You're excused.
Is there a minute order? No minute order?
There will be.
At the end of the day, you can go on the court website and pull that minute order.
Is there any other way to get it other than the website?
No.
No, okay. And I can't get a copy of the minute order in court today?
You can get a copy of the minute order and
I'm
go
sorry,
online.
go ahead.
The minute order needs to be prepared now. If you need to prepare it, you can just go on the website and send it off.
Judge, can I get a copy of the minute order?
From the clerk's office.
From the clerk's office? Okay.
At the end of the day.
Okay, thank you.
But it won't be prepared for several hours.
Okay. Won't be prepared for several hours. Got it.
Okay. Number 23. Absolute Resolutions versus Beezenson.
Morning, Your Honor.
Please raise your hand if you want. let's take a look at what we have here. All right, you have a debt that remains unpaid, so they levied on your bank account. And you're claiming that the funds in the bank are exempt from execution? Is that right?
Your Honor, they took 100% of what I had in my bank account.
I understand. You're claiming they're exempt.
Right.
If they're not exempt, they can take all of them. Do you understand?
I guess. My understanding is the garnishment, they're only allowed to take a certain percentage.
That's from your wages.
Okay, well, I have an 11-year-old son. They took out...
Just a moment. One thing at a time.
They took money out of my bank account.
Just a moment. The 75% you're talking about is automatically exempt from levy from your wages by federal regulation. California law provides that of the remaining 25%, again we're talking about wages, that amount that's necessary for the support of you or dependents is exempt. Your responsibility is to show the court in which case. Why did you work for you? Oh, you didn't pay your $60 notice. Oh, the plaintiff didn't file it. Oh, the plaintiff didn't file it. Anyway, what's the source of the money in the bank?
Can you repeat that, Your Honor?
Sure. What is the source of the money that's in the bank?
The source?
Where did the money in the bank come from?
My work. I get paid every 2 weeks.
How did it get deposited in the bank?
Via direct deposit.
It is a direct deposit?
Yes, sir.
You have some proof of that?
I have bank statements right here. Your Honor, may I ask a question?
Sure.
When this money got taken out of my bank account, I was not notified, no nothing, via mail, call, anything.
You said you had a question.
2 days after the money got taken out of my account, my mom receives a letter saying that I have a certain amount at this time.